the Group 2 will discuss about legal guidelines and law guidelines in Data Privacy Act. Presenting are the members of the Group 2. They are Maria Ronaldin Pakiding, the leader and the discussant 1, Dina Barola, discussant 2, Zaira Maralit, discussant 3, Regine Luis Villegas, discussant 4, Daisy Rose Villas, discussant 5, and Jerica Silva.
Good day everyone, I am Dina P. Barola and today I will discuss what is Data Privacy Act. So the Republic Act 10173, or also known as the Data Privacy Act of 2012, is a law that seeks to protect all forms of information, be it private, personal, or sensitive. It is meant to cover both natural and juridical persons involved in the processing of personal information. So this act is made to protect individuals from unauthorized processing of information that is private, not publicly available, and identifiable. So it protects our personal details such as our name, address, TIN number, SSS number, contact numbers, bank account details, ATM and credit card details, or any other information. So for example is answering a survey questionnaire for a research. So typically, it requires our personal information such as our age, gender, and email address. So before we participate on answering the survey, we must first be informed on why and what are they going to do with the information that they are collecting from us. In addition, the reason should be purposeful or lawful. That is why it's also prohibited to take a screenshot of any document or a photo of someone without their consent, because such information can easily identify and may harm the person involved. If we violate it, we will face some penalties or charges. So, the Data Privacy Act of 2012 involves three persons. So, first is the data subject. It is the individual whose personal, sensitive, or privileged information is being processed. So, in a given example about survey, the participant or the respondent is not considered as the data subject because it was his or her personal information that is being processed. Second one is the personal information controller. It refers to a natural or juridical persons or any other body who controls the processing of personal data or instruct another to process personal data on its behalf. Hence, in my example, the researchers are considered as the personal information controllers because they are the one who made the decisions on what data should be collected from people, who to collect it from, and what its purpose. Last one is the personal information processor. So it refers to any natural or juridical persons or any other body to whom a personal information controller may outsource or instruct the processing of personal data pertaining to a data subject. The teacher of the participants are considered as the personal information processor because they has not decided on what data to collect, but they are given the data of the data subject by the controller.
The next is the scope of Data Privacy Act. The Data Privacy Act is broadly applicable to individuals and legal entities that process personal information with some exceptions. The law has extraterritorial application applying not only to businesses with offices in the Philippines, but when equipment based in the Philippines is used for processing. The Act further applies to the processing of the personal information of Philippine citizens regardless of where they reside. But what are the personal informations we are talking about here, or what makes an information personal? The things that we must consider in personal information. The law defines sensitive personal information as being about an individual's race, ethnic origin, marital status, age, color, and religious, philosophical, or political affiliations, about an individual's health, education, genetic or sexual life of a person, or to any proceeding or any offense committed or alleged to have committed, issued by an government agency peculiar to an individual, such as social security number, and last is marked as classified by executive order or act of Congress. So, the Act and these rules apply to the processing of personal data by any natural and juridical person in the government or private sector. They apply to an act done or practice engaged in and outside of the Philippines if first, the natural or juridical person involved in the processing of personal data is found or established in the Philippines, and that is our number one. Next is the act, practice, or processing relates to personal data about a Philippine citizen or Philippine resident. Next is the processing of personal data is being done here in the Philippines, or the act, practice, or processing of personal data is done or engaged in by an entity with links to the Philippines, with due consideration to international law and committee, such as but not limited to the following. First is the use of equipment in the country or maintains an office, branch, or agency in the Philippines for processing of personal data. Next is our number two, the contract. A contract is entered in the Philippines. Next is a juridical entity unincorporated in the Philippines but has central management and control in the country. Next is an entity that has a branch, agency, office, or subsidiary in the Philippines, and the parent or affiliate of the Philippine entity has access to personal data. An entity that carries on business in the Philippines, and lastly is an entity that collects or holds personal data in the Philippines. As what I have mentioned a while ago, there are also exceptions. All processing of sensitive and personal information is prohibited except in certain circumstances. The exceptions are consent of the data subject, pursuant to law that does not require consent. Next is necessity to protect life and health of a person. Next is necessity for medical treatment. And lastly is the necessity to protect the lawful rights of data subjects in court proceedings, legal proceedings, or regulation. Therefore, with all of this, we can say that the importance of knowing the Data Privacy Act protects the privacy of individuals while ensuring free flow of information to promote innovation and growth. It regulates the collection, recording, organization, storage, updating or modification, retrieval, consultation, use, consolidation, blocking, erasure, or destruction of personal data. And lastly, it ensures that the Philippines complies with international standards set for data protection through National Privacy Commission or NPC. And that is all for the scope of Data Privacy Act.
Moving on with the topic, we are now on the legal basis, and I am Maria Ronaldin Pakiding to discuss about the legal basis with Data Privacy Act. The Data Privacy Act of 2012, or also known as the Republic Act Number 1017-3, was the first comprehensive law covering the data privacy in the Philippines. It became enforceable on September 8, 2012. Legal basis. These are the principles and regulations established in a community by some authority and applicable to its people, whether in the form of legislation or of custom and policies recognized and enforced by a judicial decision. We have 6 legal bases with data privacy. First one, consent. The processing of personal data may be permitted if the data subject has given his or her consent. Number 2, contract with the data subject. The processing of personal information may be permitted if the processing of the personal information is necessary and related to the fulfillment of a contract within the data subject, or in order to take steps at the request of data subject prior to entering into a contract. Legal obligations. These are the processing of personal information may be permitted if the processing is necessary for compliance with a legal obligation to which the PIC is a subject. Interest of the data subject. The processing of personal data may be permitted if the processing is necessary to protect vitally important interests of the data subject, including the life and the health, public interest, the processing of personal data may be permitted if the processing is necessary in order to respond to national emergency, to comply with the requirements of public order and safety, or to fulfill functions of public authority which necessarily include the processing of personal data for the fulfillment of its mandate. Lastly, legitimate interest of the data controller. The processing of personal information may be permitted if the processing is necessary for the purposes of the legitimate interest pursued by the PIC or by a third party or parties to whom the data is disclosed with, except where such interests are overridden by fundamental rights and freedoms of the data subject which require protection under the Constitution of the Republic of the Philippines. With that, the Act and its implementing rules and regulation provide that a PIC and PIP shall be accountable for complying with the requirements within the Act and the rules and regulations issuances.
Good day everyone, my name is Regina Luis M. Villegas and I will be discussing Rule 8, Rights of Data Subject, specifically Section 34 and Section 35. Section 34, Right of the Data Subject. There are 6 rights under Section 34 and these are right to be informed, right to object, right to access, right to retrification, right to erasure or blocking, and right to damage. Right to be informed refers to the data subject's right to know when his or her personal data will be processed or will have been processed. Before entering his or her personal data into the Personal Information Controller's processing system or as soon as the practicable thereafter, data subject should be alerted and provided with enough and accurate information about his or her data, purpose, scope and method, and time frame in which his or her data will be stored. Data collection and processing without the data subject's knowledge and explicitly agreement is prohibited, and the entities in possession of personal data are required to notify data subjects of any data breaches or compromises. Right to object. The data subject has the right to object to the processing of his or her personal data for direct marketing purposes, automated processing, or profiling. This requires consent from the data subject before collecting and processing his or her information. With this, the data subject has the right to refuse to the consent or even withdraw his or her consent. Any activity involving a data subject's personal data without his or her agreement is prohibited, as previously indicated. Right to access. The data subject has the right to access any entity possessing any personal data to provide the data subject with a description of such data in its possession, as well as the purposes for which they are to be or are being processed. The data subject has the right to access to the details about the processing of his or her information, such as period for which the information will be stored and the recipient to whom the information may be disclosed. Right to retrification. This right allows the data subject to contest any inaccuracy or error in his or her personal data processed and have the personal data controller fix it right away. In accordance with this, the data controller must ensure that the updated and retracted information is available and that third parties who receive the inaccurate data are notified upon the data subject's request. Right to erasure or blocking. This allows the data subject to suspend, withdraw, or order the blocking removal or destruction of his or her personal information from the Personal Information Controller's filing system upon discovery and substantially proof that the personal information is incomplete, outdated, false, unlawfully obtained, used for unauthorized purposes, or is no longer necessary for the purpose for which it was collected. Lastly, data to damages. Within this right, the data subject will be compensated for any losses incurred as a result of such incorrect, incomplete, outdated, false, illegally obtained, or unauthorized use of personal data, taking into consideration any infringement of his or her rights and freedoms as a data subject. It can be gleaned from the rights that the Data Privacy Act of 2012 is comprehensive in its protection to the data subject. This act strengthened the right of data subject about his or her personal data that was held by different electronic processing system. Now let's proceed to Section 35, Transmissibility of the Rights of the Data Subject. The lawful heirs and assigns of the data subject may invoke the rights of the data subject to which he or she is an heir or an assignee at any time after the death of the data subject or when the data subject is incapacitated or incapable of exercising the rights as enumerated in the immediately preceding section. This section states that when the data subject are unable to exercise his or her right within this Data Privacy Act, perhaps because he or she is already dead, or even if he or she is unable to do so, his or her heir or an assignee can appeal in behalf of him or her.
Good day, everyone. I am Daisy Rose Elvilias, and my report is about Section 36, Right to Data Portability, and Section 37, Limitation on Rights. First, let us discuss Section 36, Right to Data Portability. This section pertains to the rights of an individual to have a copy of his or her information being processed electronically or by any means. It allows individuals to obtain and reuse their personal data for their own purposes across different services. It allows them to move, copy, or transfer personal data easily from one information technology or IT environment to another in a safe and secure way without affecting its usability. For example, a user on Facebook may import contacts from Google's Gmail email service, or if you wanted to transfer your contacts to Shopee from Messenger. Next is limitation on rights. This section simply stated that the sections that were discussed under this act is not valid if the gathered personal data are used purely for scientific and statistical research, as long as it will be taken with utmost confidentiality and will only be used for the declared purpose of such research. The preceding sections are also not applicable to the processing of personal data gathered for the purpose of investigations in relation to any criminal, administrative, or tax liabilities of an individual. The main limitation of an individual is until the purpose of the given research or investigation is complete or accomplished.
Penalties of Data Privacy Act of 2012. Section 52. Unauthorized processing of personal information, sensitive personal information. A person who processes personal information without the consent of the data subject or without being authorized under the act of any existing law face imprisonment of for 1 year to 2 to 3 years or 3 years to 6 years as well as monetary fine. Section 53. Assessing personal information and sensitive personal information due to negligence. Person who due to negligence provided access to personal information without being authorized under the act of any existing law will face a penalty of imprisonment ranging from 1 year to 3 years or 3 years to 6 years as well as monetary fine. Section 54. Improper disposal of personal information and sensitive personal information. A person who knowingly or negligently disposed, disregard, or abandon the personal or sensitive information of an individual in an area accessible to the public or have otherwise placed the personal or sensitive information of an individual in its container for trash collection face a penalty of imprisonment with monetary fine. Section 55. Processing or personal information and sensitive personal information for unauthorized purposes. A person processing personal information or sensitive personal information for purposes not authorized by the data subject or otherwise authorized under the act of existing laws, a penalty of imprisonment ranging from 1 year and 6 months to 5 years or 7 years with monetary fine. Section 56. Unauthorized and access or intentional breach. And a penalty of imprisonment ranging from 1 year to 3 years and the fine of not less than 500,000 pesos but not more than 2 million pesos shall be imposed on person who knowingly and unlawfully or violating data confidential and security data system breaks in any way into any system where personal and sensitive personal information are stored. Section 57. Concealment of security breaches involving sensitive personal information. A penalty of imprisonment ranging from 1 year and 6 months to 5 years and a fine of not less than 500,000 pesos but not more than 1 million pesos, shall be imposed on person who, after having knowledge of security breach and of the obligation to notify the Commission pursuant to Section 20 of the Act, intentionally or by omission conceals the fact of such security breach. Malicious disclosure. Any person information controller or any personal information processor or any of its official employees or agents who, with malice or in bad faith, disclose unwarranted or false information relative to any personal information or sensitive personal information obtained by him or her shall be subject to imprisonment ranging from 1 year and 6 months to 5 years and a fine of not less than 500,000 pesos but not more than 1 million pesos. Section 59, Unauthorized disclosure. Any personal information controller or personal information processor or of any of its official employees or agents who disclose to a third-party person or sensitive information not covered by the immediately preceding section without the consent of the data subject shall be subject to imprisonment ranging from 1 year to 3 years with monetary fine. Section 60. Combination of series of acts. Any combination or series of acts as defined in Section 52 to 59 shall make the person subject to imprisonment ranging from 3 years to 6 years and a fine of not less than 1 million pesos but not more than 5 million pesos. Section 61. Extent of liability. If the offender is a corporation, partnership, or any juridical person, the penalty shall be imposed upon the responsible officers, as the case may be, who participated in or by their gross negligence allow the commission of the crime. Where applicable, the court may also suspend or revoke any of its rights under this Act. Section 62. Large scale. The maximum penalty in the corresponding scale of penalties provided for the preceding offense shall be imposed when the personal data of at least 100 persons are harmed, affected, or involved as a result of any of the above-mentioned offense. Section 63. Offense committed by public officer. When the offender or the person responsible for the offense is a public officer as defined in the Administrative Code of 1987 and the exercise of his or her duties, he or she shall likewise suffer an accessory penalty consisting of disqualification to occupy public office for a term double the term of the criminal penalty imposed. Section 64. Restitution. Pursuant to the exercise of its quasi-judicial function, the Commission shall award the indemnity to an aggrieved party on the basis of the provision of the new Civil Code. Any compliant filed by a data subject shall be subject to the payment of filing fees unless the data is indigent. Section 65. Fines and penalty. Violation of the Act. These rules, other insurance or orders of the Commission, shall upon notice and hearing be subject to compliance and enforcement orders, cease and desist orders, temporary or permanent ban on the processing of personal data, or payment of fines in accordance with the schedule to be published by the Commission.